started. And so I'm going to go ahead and introduce our speaker. Don McNay, he's about the closest thing to a Renaissance man that I know because he does different things. He's a financial consultant. He's a columnist with the Huffington Post. He's an author. He's now a best-selling author with his most recent book, Wealth Without Wall Street, A Main Street Guide to Making Money, which is a pretty timely book to come out at the present time with the way as we see the world developing. He's also the author of a book called Son of a Gambler, Winners and Losers and What to Do If You Win the Lottery. So when you win the lottery, I'd recommend that your first or your second call be made to Don because if you see on CBS or CNN, usually when they're looking for somebody to comment on something having to do with the lottery or a lottery winner, he is one of the first people that they make a telephone call to because he is an expert in that area. And then today, what he's going to be talking to us about are innovative settlement techniques. And Don is one of the pioneers of the area of financial expertise, structured settlements. And I guess I first became exposed to Don 25 years ago. I didn't even know what a structured settlement was, but then a lot of other people didn't either. And so he is the chairman of the board of the McNay Settlement Group in Lexington and in Richmond, and is acknowledged as a world-class expert in structured settlements. So I'm grateful that we could have him with us here today. And like I said, he's not Lee Greenwood, but you do get 1 hour of credit for listening to him. That's an advantage.
Thanks, Jimmy.
Thanks, Don.
Jim and I have been friends for a long time, and he's a good lawyer, but he's a better man, and so I always appreciate that. And so it was an odd experience coming in here across the parade and everything else. I appreciate you all being here, and wasn't expecting a marching band and parade to have me in town. As Jim mentioned, I have a book, Wealth Without Wall Street. Came out August 25th. August 27th, it was the best-selling business and investing book on Amazon. It was it's still in the top 100 in various different categories, small business, personal finance, that kind of thing. But a couple of things have knocked me out of the number one slot in the last couple months. But it's been a fascinating experience. I've never had one of my books do that well before. I've got a couple of them to sign at the end of the presentation. But first things I want to talk about are actually from the book, which are kind of not related to the settlement world, but I just thought were good, practical things to know. The book's common sense financial planning. It's the easiest way to describe what it is. So if you read any review, they say the same thing over and over again. It's common sense. And but common sense doesn't always prevail these days. And I guess one of the reasons I want to talk is about a simple thing about why you need a will. There's a chapter in my book about this, and it's not for. Please tell me everybody in here has a will, or has some idea, But getting your clients to get a will is a problem, Getting family members to get a will is a problem. It's 50% of Americans don't have wills. If you get it down to younger ages, it's like 80% and below 30. So, and I have my own story, which I have my nephew back here, Nick McNay. He's a videographer in Cincinnati and volunteered to come down and help me today and get all this on tape. But he's actually part of this story. I know hundreds of estate planning attorneys, expert on trust and all that sort of thing. But my mother died April 2006, no will. And that didn't seem like a big problem because it was just my sister and myself. And the deal was we'd split it. The only thing she really had was a house, and we'd split the proceeds. What we came up with was that I would buy the house, rent it back to her, and then her share. We had a system where she could keep on living in it for a while. And got a little more complicated because my sister, Nick's mom, died in October. Fell down a flight of steps and died. No will, no, and even more interesting, she had something else I didn't know about, a husband. And so she had been theoretic, I thought she was divorced for 8 years. I thought that she she had lived in California most of the time, and he had lived in Cincinnati, but showed up at the funeral, didn't say a word. Then he popped in Monday to get himself appointed the executor of the administrator of the estate, and so and we fought that out and all that sort of thing, and ultimately Nick back there became the person in charge. But bottom line, if you read the chapter, was that my family, my brother-in-law, my ex-brother-in-law, or I guess legally my brother-in-law, wound up getting half the money for my sister's part because there's no will, and he got part of my mother's money because we hadn't settled mom's estate before my sisters had come through. And the lesson, it's interesting when I read reviews of the book or commentary, this is the one chapter people seem to remember as much as anything. One, because it was kind of bizarre, and second, it was painful. It was a horrible year. It was split our family terribly. And third was, my family, I feel like we should have known better. It's like, if some of you are lawyers and somebody in your family doesn't have a will, you feel like you should have been pushing it. You should have been, I had two, and it didn't have it. It didn't really have any estate planning set up at all, and it came out with just very difficult consequences. So I've been using, a lot of lawyers have been using this one and the next article, the case for consulting with an attorney. I excerpted some of the book on Huffington Post, and I have a syndicated column that runs in CNHI News Service, and so a lot of lawyers have started linking that, particularly estate planning attorneys and people who do a lot of wills and trusts, to their website because it's kind of the prototypical example of why it's important and trying to get people talked into it, which is something I've found just hard to do. And the other chapter that I have from the book, it's just something else, you might, when you're talking to clients and that sort of thing, is the case for consulting with an attorney. And I've met a lot of people who have tried to do things on their own. They've tried to go out and deal with an adjuster on their own. They've tried to write up a will or getting forms online. People try to do tax and estate planning sorts of things, and they don't want to pay the money for a lawyer, or they don't want to hire one, or they don't want to do anything that involves bringing a lawyer into their world. And so the chapter in the book is essentially about why you need to do that, encouraging people to do that. And it must be working, because I have a little thing in the book that I mentioned on Huffington Post. I said, if you can't find a lawyer, email me and I'll refer you to somebody in your area. And now I haven't had any in Pikeville, but I get them from all over the country on a real regular basis. And so obviously two things. One is that people have read it and are interested in the topic, and the other is that they don't always know where to go, and they don't have a real good system for finding an attorney. And there's advertising, there's referrals, and that sort of thing. A lot of them, people find their attorneys through church or social groups, but there's a world out there where people don't belong to any of those things. And so just I talk about that. I go into a little more detail in the book, just why they, the different ideas and why people should find an attorney. Just a quick, go through the room. What type of law does everybody practice here? I'll start with Baird and we'll go around.
Civil defense.
Yeah.
Various. Plaintiff's work.
Okay.
Workers' comp.
Okay.
Various, whatever I'm told.
Okay.
Civil office practice.
Okay. Okay.
Defense, insurance defense, and various others.
Okay.
General practice, including estate planning.
All right. Good. Mm-hmm.
General.
General.
General practice.
Okay.
Civil defense.
Okay. Yeah. So everybody's, somewhat along the lines of what I'm going to go to next, which is one of my areas of really. Jim talked about structured settlements, but really one of the things I'm interested in is talking about guardians and guardianships and conservators and conservatorships. And there's a Supreme Court case, Branham versus Stewart, which I think a lot of people are going to be familiar with that here because Ira, the named attorney, was one of, and it was named one of the 10.
It was my case.
It was your case? You had the other. You had the other.
No, I had Brown.
You had Branham? Okay. Well, I'd love your insights on it because it's, on one hand, it was a case about, really about my understanding is, it was a case about representing, whether or not he had a duty to represent the minor. That's the way I understood it. But a lot of things came in as far as guardianships and I like Ira, and I always thought this was a good example because when you think of legal malpractice, you think of somebody either incompetent or like fen lawyers are stealing the money, or Ira's a good lawyer, a good guy, and just a lot of weird things happened. But the things that came down that really made it complicated was the, not requiring enough bond, and the fact that the guardian who was appointed was not financially sophisticated. It was, I guess, the mother-in-law or the mother, and didn't come out with and rather than appointing an outside conservator or something like that, which is what we do a lot of, is to come in and we do two different things. One is to come in as a limited guardian where I'll testify in court. I just did that. In fact, I was afraid I may have to cancel it because I was in court last week in Lexington on a trial that's still going on, but I had to wait 4 days to do my 5 minutes of talk, which to come in and say that if this child gets the money's going to the child, and it's not going to go to anybody else. That's what it's been pretty effective when I do that. I had a string there for a while where everyone I testified in was $1 million case. So I kind of thought, this is kind of, well, a lot of it's just people only were using me on bigger stuff. But I think that connects to the jury that if you have, be honest with you, parents that they don't like, or parents or guardians who they're not that crazy about. But the thing with Ira's case was if he had if they had appointed a conservator, that would have solved, would have gotten that whole thing from never happening. And also, if he had put the money in something called a qualified settlement fund, which is something else I want to talk about in a little bit. So, and he did a lot of things right. Put $300,000 of the money into a structured settlement. He got bonded. A lot of times courts used to be really lenient about waiving bonds, or in this case did a minimal bond, and not really doing a lot of things to qualify who the guardian is or who the guardian's not. And so I have a group called Kentucky Guardianship Administrators, and we've been doing it for about 20 years now. Never really advertised it much, but it's just, we've got a pretty good business, but it's basically to prevent two things. It's prevent guardianship theft, to prevent, two things I want to do. One is to make sure that we're legally staying within the right bounds, that everybody is, that the money is going to the right person and it's going to the child, usually the juveniles who we're working with. Second thing is to make sure that when the child turns 18, they don't go through all the money in 6 months or 3 months or 3 weeks. Or I had somebody go through $600,000 in 3 weeks one time. It's just, you say it doesn't happen. Jim talked about my work with lottery winners. And 90% of all people who win the lottery will blow through their money in 5 years or less. And they think, well, maybe that's just unique to lottery winners because they're coming into a situation where, on Tuesday they're a mechanic, on Wednesday they're a multimillionaire. There's no life training. But 72% of people who inherit money will blow through it all in 5 years or less. 60% of all professional athletes, if you're an NBA basketball player, you'll be broke 3 years after you leave the league. Antoine Walker, who, famous University of Kentucky basketball player, he's bankrupt. He actually put him in jail for gambling debts in Las Vegas because if you don't pay the casinos in Las Vegas, they apparently put you in jail for that. Right? And and he ran through $110 million that he had made in the NBA. But and you think that's incredible, and it shouldn't happen, but it happens all the time. And the big thing is I've got it down to a couple of things: family and friends, and that's not just NBA basketball players or lottery winners. You people come in for injury cases, and they show up with 20 of their friends, and they all want to buy them new trucks and or whatever, and or they get a new boyfriend, and so I told one of my lottery winners once. I said, you just became the best looking woman in your town. She's just going through a divorce. And I said, you're going to be amazed how many guys just suddenly think you're beautiful. And, she shows up with some guy, and he wanted to help her with her money. And I'm like, nah. And so there's that window of opportunity to try to, I always kind of view it like weight loss, that you try to I fight with my weight, and that's something I've done for years. And the only way it works for me is to get rid of as many temptations as possible, and so to try to keep things simple. And going back to my book, I preach, investing slowly, investing for a long time, being conservative with the money, and also not having credit cards, and just trying to, trying to put some sanity and live below your means. And so the whole idea with guardianships, the whole idea behind that is it's like the Will Rogers thing, what he said in the 1930s, I want return of my money, not return on my money. You want to get a good return, but obviously the main thing I worry about is trying to make sure nobody else runs off with it, or they don't do something stupid in the first few years. And there's a lot of, I cite a lot of different things, and you can go through every one of them here. Got all the different statutes in my outline, and the one I don't see I see it with blocked bank accounts, but I don't see it enough. And this is something on smaller cases. I try to get the courts to encourage them to direct the money into an annuity, like a structured settlement, or a trust, or you can do the blocked bank account. The bank account. The one downside there is they get all the money when they turn 18. It also is a resource for financial aid purposes. If they're going to college, they have to count that money. It might knock them out of financial aid. I'm not sure why money in a structured settlement is not considered a resource for financial aid purposes, and the trust, depending on how it's set up, you can avoid that as well. And but I go through the duties and the limit of the conservator, and the ideas of avoiding. The one advantage of on a smaller case in particular is if they direct the money into a trust or into the court directs it, you can usually avoid bonding, which is harder and harder to do. When I first started doing it, it was they bond pretty much anybody, and now. I don't know if anybody else has run into this problem, but finding a bond for people can be difficult at times. And the other thing is the tax advantage, which, depending on the circumstances and the person, that can be complicated as well. Dying to get any other thoughts you have on this, on our. Go ahead.
I'll share with you afterwards.
Okay.
The rest of the story.
Yeah, I wondered, because I got the idea there was a rest of the story, and I thought Judge Scott's dissent was really interesting, which I've got in my outline, that he was saying that, this is going to do it the way that they laid out in the opinion. You'd have to have 3 lawyers on every single case in order to walk through it all, and I suspect he's probably correct, and I don't know how it's really shaken out since then. I do know people are a lot more inclined, since this case came out, and it was a Supreme Court case, I've had more people want to do conservatorships or want to just do something to get themselves out of the line of fire to some extent. And
I was the one that paid all the money.
Did you really?
Yeah.
Oh, okay. So everybody knows that case pretty well, huh?
And I'll tell you that lady was not unsophisticated.
Oh, she wasn't. Huh?
Just a thief.
Oh, okay. Well, sophisticated thief is really difficult.
Actually, I said her husband was the thief. She was fine. It was the husband.
She got remarried?
It was the evil stepfather.
Well, and that's actually, in all seriousness, that's a real problem. And I see that a lot, that you bring in that new dynamic there, particularly on widows and widowers. And I will say this, and do not put this out on the tape here, Nick, but the widower was what happened in this one. It's that situation too, or at least one with a different agenda. But of course, the other thing too is I guess there was no annual reports or anything that ever got filed, and that happens. And people move away, and nobody's keeping up on it. Some of the courts are fanatical. If you ever have to deal with Jefferson County in Louisville, if you're one day late, boy, they're calling you in front of the judge, and they're wanting some, they're wanting something like right now, and so we had one get lost in the, just didn't get filed properly or whatever, and I thought I was going to be in jail for the rest, I had to drive it up there and go meet with the judge like that day, so people are taking it seriously, but do y'all see a lot of guardian? How many people last year? How many people have had to deal with a guardianship case? About half, and so because they'll go through streaks, because you have to have the right environment. And the other thing we work with more and more are the other side, elder care, children stealing from their parent, or trying to set those up, and it's very complicated. I've got a distant family member we're trying to work with now, and walking through all the hoops to get somebody declared incompetent is not easy, and so but you're seeing more and more of it that way, and then just people who are handicapped, and there's a whole world outside of the litigation field where we have children with autism. I have a grandson who's has Asperger's, which is a form of autism, and so I've learned a whole lot about that universe since he was diagnosed. And there's a lot of resources, but there's a lot of parents that are going to be parents. They're going to have children living with them for 50, 60 years too. So all these things fall into the same category, making sure they're taken care of long term, trying to set up some type of special needs trust planning, things that will protect them and protect their government benefits, and is Medicaid and Social Security are getting hungrier and hungrier, looking for resources. It's you have to take a lot of care. Setting up special needs trust and becomes more important, and taking care to make sure those special needs trusts are properly set up. That's the other area that's becoming more and more common. I want to shift into the qualified settlement funds, which I know you've worked with them before. How many people here have ever worked with a qualified settlement fund before? And you, of course, yeah. And it's there's an article in your packet, and it's called from Trial Magazine, 2002, is a qualified settlement fund right for your client. I've always been proud of that one. Bill Garmer up in Lexington and I wrote this together, and it was the first article ever written in a major publication about qualified settlement funds, and you can go back and look at it 10 years later, and not much has changed there. And so the easiest way to define a qualified settlement fund is essentially almost like an escrow, where it came out of large mass torts. It came out just paying in all their money to that, getting out from underneath it. You see it like on mass torts. You see it on class actions quite a bit. I'm settling for my $100 million, and somebody else can divvy out who gets what. And what we did was very different. We looked at it from the other side and decided it was a good tool. Really, now we've worked on some very large mass torts, but our primary thing is individual cases, 2 and 3 people. You have 2 family members who are getting money, and that sort of thing. And we found that it had just a lot of different advantages from the plaintiff's attorney side. And the first, from my standpoint, it was kind of interesting that you can set up a tax-free structured settlement out of a qualified settlement fund. So if you don't like what the other side, before qualified settlement funds came along, say if I was dealing with AIG, real good example. AIG is very aggressive about pushing their own structured settlements, would not really allow you to do anything. You know, it's like take my annuity or you can't do it. And so with the qualified settlement fund, you could go out and shop the market and find something that maybe is a little bit better rate, maybe something fits your needs better, and you don't have to have the defendant involved. So that was changed that dynamic dramatically, and so how structured settlements were done, and they're all still tax free. But and of course that's what got me interested in it. But then I started seeing all the other things that can go on too. The other thing we do quite a bit of is you pay the money into a qualified settlement fund, then you go ahead and set up your special needs trust, and you get it all approved, and you make sure that Medicare and Medicaid and anybody else that needs to sign off on it has signed off on that trust, and then you wait until then to fund it, and so you have a lot more assurance that your trust is going to hold up if they start to look at it more heavily and try to audit it or whatever. I saw one recently. Somebody came in my office where it was improperly worded, and they got their SSI cut off. And I said, well, you need to redo or rework. It's going to be very, very complicated, but it just wasn't worded right. There was a change in 2009, and then nobody had caught it, and so they've been knocked. So Social Security came in and knocked them off the benefit. So with the qualified settlement fund, you can be more creative. And the other thing is deciding how to allocate the money amongst the various plaintiffs and claimants. And this is one where it's usually pretty straight. A lot of times it's straightforward. But let's take a situation where you have a husband who was injured. Wife has a loss of consortium claim. They've been married 30 years. How much is that? What percentage is hers? What percentage is? That's touchy. I mean, that's there's that argument that it should be 50% because they've been married all this time. There's that argument that it should be, since one person's injured, that it should be. So by putting it into a qualified settlement fund, you can kind of give them a meeting of the minds and things where there's going to be a fight amongst siblings, a fight amongst different parties. This gives you a chance to go ahead and get the case settled, and actually from the attorney's standpoint, you can go on, a lot of times you can go ahead and settle out, get paid, get your fees and expenses, take care of that, move on to the next deal, while all this is being hashed out with the qualified settlement fund administrator. And I've run into that before, and I've run into that many times where there's if there is a fight amongst the families, I've had people just want to put it in a qualified settlement fund just to say Jim here, just to get you out of you're not telling your clients, oh, by the way, you get this much, you get this much. You've got an uninterested third party to do it, and did a big mass tort several years ago. And there was, I guess, 84 people involved and a lot of money. And what we did there was we put all the money in a qualified settlement fund. Then they had a mock mediation for all the cases, and had the mediator kind of decide, well, this is how much I would give. And then from there, I was able to take the percentages, say if he said it was worth $5 million, but the allocation would be like $2 million or something like that. I was able to take all the percentages and make it work out, and it was a mass tort. It wasn't a class action. Everybody had to sign off individually, but everybody did once by putting it in this fund, taking this extra step, and the big Fen-Phen case that came up in Covington, which has resulted in huge publicity and several lawyers being disbarred now. Of course, a lot of it was their fee was so large, but the allocation thing, they ran into a problem too. And if they had used a qualified settlement fund there, they might have solved a lot of those issues. And so it's a way to kind of get the attorneys out of a legal malpractice or firing line situation, and also just the ultimate goal is to get the clients happy and get them all on the same page. And let me take another drink here. But the other thing, and I go along the same thing in the outline, is to family members fighting with each other, where there's not a clear cut, who gets what, and then gives you an opportunity to do that. Another large thing I've seen qualified settlement funds used for is structured settlements on attorney's fees. And you can, an attorney can structure their fee out over time. There's a lot of tax advantages to it. In days when the markets are losing 40, 50%, a lot of times the financial advice, even, people are making, because the rate of return is still better than, say, bonds or putting it in the bank or something like that. But they can set up a qualified settlement fund to do their attorney's fees, even if their clients don't want to do a structured settlement or do anything else. Even if if the clients still want cash, they can still do a structured settlement on their attorney's fees, provided they walk through this qualified settlement fund hoop. And then we see a lot of that, and particularly around this time of the year when people are doing their tax planning. And this is something, when I first started working with qualified settlement funds, I thought this would be a big thing, that people would take all the time they wanted to make a financial decision, and rather than be rushed into it. And I had a woman who's lost her entire family, father, mom, brother, and just froze for about a couple of years, really, and just could not. And she'd had some other money coming off the life insurance, wasn't in a big hurry, but just could not commit to doing anything, just emotionally. And rather than saying, okay, we've got to do something right now. And I think a lot of times people make bad decisions after, one of the reasons they run through a settlement so quickly is they're rushed into making decisions. They haven't thought it through. They haven't really decided what they want to do. I talk about that in the book, about projecting out what you want to do with your life afterwards, and how that fits in. And I get that from here. The people who've come into money from an injury settlement, and two things going on. One is that it's a lot of money that they're not used to having. The second thing is it comes from something horrible happened to them. If you're in an injury settlement, it means, one, you're injured, or two, somebody died. And so that's why you get injury settlements. So, and emotionally, they may not be, on the game. And if you go talk to somebody who's going through a life trauma, like I mentioned that in my book, I lost my mom and sister and went through a divorce in a 9-month period of time. And, I made I think I'm smart about finances as anybody, but I made some dumb decisions during that time period, because the emotions, come into play, and you do things that don't always work for you. And you go back later and think, man, why did I do that? But and so by putting the money aside for a bit and just getting yourself emotionally stable, that's the way. To me, that's worth quite a bit, and it's one of the big advantages of setting up a qualified settlement fund. So it's people in my biz try to make a big deal out of qualified settlement funds being very complicated, because we don't want people. We want people to call us to do it, but it's pretty easy to do. So it's it just requires a couple of documents, paperwork, and actually a lot of times it's easier than doing a structured settlement through working through an insurance company or something like that, or anything else. It's turned out to be a pretty streamlined system. A article that I have in my pack. It's not in the packet because it's called Structured Settlements and Special Needs Trust, and it's a national underwriter, and I can get you one if you email me or whatever. But it's the whole idea of using special needs trust, I think, is the wave of the future. Not just, like I said earlier, because injury, but also because of people that have other types of non-injury type of money. Because protecting government benefits, that's, if you talk to the average person out on the street, that's the one thing that people stay in jobs for a long time because they're afraid of losing their health insurance. They will stay in situations. I've seen somebody staying married till the husband, so she can vest for the husband's health insurance benefits. The people who are getting Social Security or getting Medicare, Medicaid, I mean, you get cut off of your Medicare or Medicaid, that's a couple $100,000 decision that could go your way, depending on how expensive hospital bills are. So people want to do everything they can to protect themselves with the special needs trust, and I'm seeing that as just of any kind of field that I'm seeing as a growth field within what I'm doing within the legal business. I think that's one of them. And so, any questions, thoughts, or
The Medicare, Medicaid,
yeah.
set aside, like you said, with the
And particularly, and that's getting, you're getting worse and worse. And also the fact that Medicare has never really seemed to be very clear on what they're looking for and what they want, and kind of change their minds every few minutes. And we're all looking for clarity, particularly on the liability settlements. On comp, they seem to have developed a system, but on liability, it's still pretty wide open. And that's becoming the big buzzword. Whenever I go to one of these conferences, or that's 99% of the time, that's what we want to talk about these days. And so, yeah, I've got about 15 minutes, but I'm going to talk about structured settlements some more. And so, how many people here have done a structured settlement? Everybody. All right. So it's just about. And how many people here proposed it themselves, or had the other side propose it? How many people here proposed? It was your idea first. It's gotten easier, and there's that barrage of advertising. Most people, when I tell them what I do, think I work for them. And so, oh, you're by those things like on TV. I said, no, I'm on the other side. And so, but this is still the hardest state, and I know Wentworth and some of the others have made 3 or 4 attempts at the legislature, because I've gone up several times to testify or keep them from ever going anywhere. And but to try to water this down, this is the strongest state. And then there's a federal law that was modeled after what we were doing here. But they're very creative, and there's millions of dollars on the other. For about 5 years, you really couldn't do one in Kentucky. But then they're very creative, and they've worked their way back into it. And I don't like it because it's undoing. I think it's not in the best interest for the people who are getting the money, and I don't want them to blow through it all. And there are situations. I had a woman who needed a heart and lung transplant, and she was going to die without it. Okay, she needed to turn $50,000. Okay. And in fact, I found that somebody for her to do it with, and got her a pretty good deal. And so, but I do know who those. I know everybody on the. I know all the players in that market, and but I want people to structure. And I am convinced, and I've said this many times, that I think structured settlement is one of the best financial planning tools ever invented. That completely tax-free, completely flexible. You can set up the terms any way you want to. You can set them up for the rest of your life. And you look at all the people that are out there buying tax-free bonds, where they can get called in. The rates aren't normally as good. You can only do them for 30 years, as opposed to what you can do with the structured settlement. I think the structured settlement's going to blow it out of the market. You look at what's going on. When I first started, it was in the early 80s, and it was pretty easy to get 15-20% return on your stocks and bonds, your mutual funds, which people aren't doing that right now. And so in fact, the Dow went to a negative for the year yesterday, actually, and so the S&P. So it's harder and harder to make money in the stock markets, and so. And the financial part of it, the fact that all the payments are completely tax-free, that's one of the things I'm promoting. But the real thing, I'm pretty blunt with this when I meet with clients. Now, I want them not to run through the money. And so, like I said, I can rattle off all my lottery winners, but it's any person who has large money. My next book, which I've thought about including it all in this one, but we decided to split it out, will probably be about why people run through large amounts of money and how to stop it. And I hit it a little bit here, but the thing about structured settlements too is you can enhance the life if they are injured and it looks like they're not going to, they don't have to be severely injured. Anything that reduces life expectancy will help you get a better rate on a structured settlement. It's the opposite of life insurance. On life insurance, you pay more if you're a smoker. You pay more if you're overweight. You pay more if you're diabetic, or it doesn't always have to be something completely out of the blue. I mean, it doesn't have to be that you're on death's door. I have a medical person in my office. We're always looking, smoking in particular. We can always get a few years of, and if you change it to where the life expectancy is reduced by 3 or 4 years, it makes a big difference on structured settlement. So we're looking for anything there. But so with a structured settlement, the unhealthier you are, the better the rate. And so it's the opposite of, say, life insurance. And so we're always looking for that. And mentioned earlier, the attorneys can structure their fees. And there are different caveats and ways to break into them for medical expenses, and also for things like estate planning. It used to be that when you first started, if you died and left your annuity to somebody in your family, they had to just keep taking the payments. Now they could take it in a lump if they need it for estate planning purposes, which we don't know what estate planning is going to be these days. And so, and one of the things that I think is real important in people is when you're in a mediation or a settlement setting or whatever, a number is a nebulous sort of thing. If you're getting 100,000 or 300 or 300, whatever, you don't know exactly what that's going to do for you. One of the things I always do is what I call my lottery question. And I say, forget about what you're going to, forget about the settlement. If you won the lottery, what would you do with the money? And most people are kind of vague. And they say, oh, I invest it. I said, well, invest it in what? And something making more money. I said, why? What are you going to do with it? It takes you about 4 or 5 questions to drill down with what they really want. Do they really want to put the children through school? Do they really want to move to Florida? Do they really want to retire? Do they really want to pay off their house and their credit card? A lot of times people want a settlement because they're so heavily in debt, and there's people calling them 24 hours a day. They'll do whatever. And that's the motivation behind what's going to get the case settled. And and I'm looking for, say if I'm working with a planning attorney, trying to find out, because people sometimes will come in with unrealistic demands. They'll have a stub toe and want $10 million because they knew somebody who saw somebody. So trying to get them realistic, or at least some idea of what the money can do for them. And I've found that if, you want a car, you want a house, and you want to pay off your debts, and you want so much money for life, and you want the kids to go to college, that once I allocate all that, and they can see what it's doing, it makes settlement a lot easier. It breaks down a lot of different types of barriers. And as far as, sometimes people don't, my mom got hurt at work. She was a nurse in an operating room. And bad timing, her small community hospital where everybody knew and loved each other was just bought up by a big chain who jerked them around on the comp for 6 years. And part of it was Mom, because she didn't want to, she got her back up after a while, and she just wouldn't want to settle for anything. And it was just, I'm going to get back at them for, not about the emotion, it's about money. And so I said, it's not about getting even, it's about money. And so I say that to everybody that walks in here, it's about money. You got to get the other stuff. Forget about revenge. The only thing you can get out of this is money. And so how much and how it's going to be taken care of, that's the key to it. So I'm getting close to my hour here, so if anybody has any questions, it's very...
Don, it doesn't really deal with settlements, but I wondered if you had any experience or opinions about what's come about in the last year, these companies offering to lend claimants money where they don't have to pay it back if they don't win their suit. I've talked to some good friends that are plaintiffs' lawyers, and they say that the real interest rate on that is astronomical.
It's off the factory people moving into a new world, and one more way to get at it. And two things. I think it makes too much. You have somebody outside of it making too much pressure to settle. I run into situations where people can't, they have to hang in a case because they can't get settled because they can't get even again. And it's like going to a payday lender. I mean, it's essentially payday lending types of rates as far as what you're getting. And I try everything to get them, keep them going there. And these companies have gotten very aggressive, and they're everywhere. And I first started seeing them coming out of California several years ago, and now they seem to be everywhere I look. And so,
Is there any sentiment or movement that you know of to regulate it in the legislature? I've not talked to anybody who likes it.
No, I don't either, and I think it's going to take a situation like we had with the factory companies, where one, I was really interested in, lived in the same district of somebody who had a lot of clout in the legislature. But the other thing is, we found the perfect, I hate big, perfect prototype of somebody who's been wrong. The Courier-Journal did a front page story about it. When the legislature was deciding it, one day the Courier-Journal does a front page story, and I can see her picture from me to you. I'm pulling up the rack, and I'm thinking, okay, this is probably going to help. Half of the front page is her, but she was everything. She was just perfect, articulate, she's attractive, and she's been really wrong. So they need to find that kind of story, frame it that way.
Don, it's my understanding that the Bar Association or the Supreme Court,
Yeah.
whoever does that kind of stuff, is considering a change in the code of ethics which would prevent me from even telling my client that there is one of those lenders out there.
That's not going to happen. There was a proposal, and they had a hearing at the Bar Association in June, and I spoke actually at that, and against that proposal for a lot of reasons, because it would also keep you from referring your client to me and a lot of other things. And I've talked to almost every Supreme Court member since then who said it's dead. I don't know if it's officially dead, but privately, publicly, they've all said that this was really, there's one member of the Board of Governors who had a problem. It was kind of a private thing between two lawyers that wound up becoming getting it in a proposal. And one of the justices told me, he said, anybody can make a proposal. And so, but that got a lot of attention. And because it was interesting, my allies there. I was there with the head of the Medical Association, and I was there because they couldn't refer doctors anymore. I was there with the chiropractor, there was an orthopedic surgeon, there was accountants, and so we all went to the hearing from Lexington. It was an interesting group of people that we'd assembled there, but I was one of the people who spoke against it, and really, it was going some. I think the people that were for it just sat down and didn't speak for it. It was kind of going the other way, and they knew it. But no, bad idea. But I can see in one hand where they might have had I can see a motivation, but I think it was just poorly worded, poorly thought out. So.
Well, I caution my clients a great deal about that sort of thing, and I tell them, I say, look, if you've got an uncle or a cousin that will go to the bank with you and
Right.
co-sign a note, you'll get a lot better deal.
Right.
And if you want to reassure your cousin, we'll fix him a letter that you'll pay that out of this settlement. And it also, you have people, if a man can get $1,000 to keep from getting kicked out of his home,
Right.
He'll give you more time to work about it.
Exactly. And, if they're credit worthy at all, and a lot of people are, and they have property, like if they come to me in Richmond, 17 banks in Richmond, and I know all of them, and you explain, here's what they're up to, and that sort of thing, and we work with them. And one time it was really easy to do. Credit standards have gotten tighter, but they're still, rather than just starting off, but I think a lot of people don't just think, well, I can't get anything else. And it's the same reason people apply for credit cards in the mail and online, is they don't realize they're paying 36, or there's one card that charges 78% interest. But it's but people don't know that they can go down to the bank and maybe get a better deal. They don't have a relationship with their bank, and so, or if they do, they do it with the teller or something like that. They don't know. I had somebody, a good friend of mine, come in the other day. So you ought to refinance your house. It's like So, oh, they told me I couldn't do that. I said, who did that? Well, the lady, dealt with me at PNC. I said, so what, she's a bank teller? I mean, I said, I'll get you to a mortgage broker. They're dying for this type of business. You have good credit and good and steady income. It's, you get it down below 4% right now. So a lot of it's just, not knowing who to go to and just common sense. And I want people to say, oh, by the way, if you're going to do this, let's go talk to the bank. Or if you're going to cash out your structured settlement. I've talked people out of it before, but it's harder and harder. And, if they're up to their debt next in credit cards and they're looking for something else, I do my best to keep them. I've always viewed it kind of like a drug and alcohol counselor. If I went by the people that didn't make it, I go crazy. I have to look at the ones that are success stories. That's what we can do. So, anybody? Well, thank you. I appreciate y'all having me.